My name is Aisha Solomon. I'm the Alachua County Property Appraiser. Yay! Thank you. I would like to first thank Elder Care Senior Center for allowing us to host this event here in the community. I would also like to thank each of you for attending tonight. I think this is the largest turnout that we've had. So thank you for showing up. You're welcome. And I also like to thank our panelists. We're hosting this event here because nearly 3 out of 100 residential properties in the Northwest Gainesville in zip codes 32605 and 32653 are at risk of entering a costly and lengthy probate legal process. Probate process, yes. This ongoing collaborative initiative serves as an opportunity to be more accessible to residents who may be impacted by these issues. This interactive panel discussion features representatives from the Alachua County Clerk of the Court, the Alachua County Tax Collector. Oh, he's helping. Look at him. He's helping getting chairs out. And the University Levin College of Law, and Three Rivers Legal Services. Each panelist will discuss how their respective offices are directly impacted by the extensive probate process and provide insights on the preventative measures to help these issues and answer any questions the audience may have. For this Probate and Estate Planning Summit, our office took a data-driven approach to identify properties in the county that are classified as heirs properties and have one remaining owner, which may indicate a need for probate or estate planning. Through this data, we were able to analyze hotspots areas in the community and identify central locations to best host these events such as this one. We plan to continue to host events throughout the county to ensure that we are educating as many residents about this process as possible. Thank you for your time and enjoy. Learn a lot. This event will be photographed and recorded. These videos and/or videos may be used for publication, news releases, online, and in all other forms of communication, both digitally and in print, as our offices sees fit. That's just a disclaimer. Now we're going to turn it over to Danae.
Thank you, Aisha. My name is Danae Wright. You could call me Alex Trebek. I'm going to be the MC here tonight. So I teach at the Levin College of Law. I teach estate planning and I teach real property. And I have gotten very involved with this subject because I've seen on both sides what happens if people don't do take a few simple steps before they pass to make sure that their real estate passes to the people that they want it to pass to. So, you can't take your stuff with you when you pass. You have 3 choices. You can give it away during life, which, for those of you who know Shakespeare's King Lear, did not work out very well. He had ungrateful daughters who didn't take care of him. You can do nothing, which means that the law will identify who your legal heirs are and will divide your property among them regardless of your preferences. And if you think about this, let's say you've got 3 kids. You've got a box of Cheerios. The box of Cheerios gets divided into 3 shares. Now, they don't have to do it that way, but the law says everything gets divided into 3 shares. Not a really sensible way to have property pass. The third thing, which is what we're here to hopefully encourage you all to do, is to write a will or create an estate plan that identifies who you want to have get your stuff. So one person gets the coffee maker, and one person gets the TV, and one person gets the, the microwave, instead of everybody getting a third and a third and a third. As we know, there are risks, right? Since you can't take it with you, there are risks that if you give up control too soon, like King Lear did, you're not going to have enough for your senior years. And none of us want to do that, right? We don't want to be a burden on our children. I'm okay being a burden on my parents, but I don't want them to be a burden on me, right? But anyway, you don't want to be a burden on your children. If you don't do anything and you leave your estate to pass by the statutory laws of intestate succession, which is what it will do if you don't do an estate plan, you're going to have to rely on your heirs to actually do the work. They're going to have to probate your estate. They're going to have to pay for it. They're going to have to get along and decide what to do with everything. But and it can be expensive. And if they wait too long, it's going to be expensive, a process to go through the probate process. We're going to talk about that. The lowest risk and least expensive process is if you do an estate plan. And we have Three Rivers here who's going to talk to us, with Stephen, not Three Rivers itself, who's going to talk to us about the various aspects of estate planning. But I want to talk to you about this idea called heirs property. So heirs property happens when real property, we're talking about real property, because real property, it's really hard to get that real estate into the hands of the next generation. Like you can just hand over the microwave or the box of Cheerios, but it's hard when you've got real estate, a piece of real estate where you've got legal documents, right? So heirs property happens when the landowner dies and the heirs have not done the work to get the title records fixed, to get them caught up, to get them updated to reflect who the new owners are. So why is it bad? Well, it creates it's called cloudy title. So we're going to talk about four things tonight. Cloudy title, and there's going to be a test on it, by the way. So, right, cloudy title. Write that down. No, you don't have to write that down. Cloudy title is the first. That's when the official records have somebody else's name. So it might be grandma's name, it might be great-grandma's name, it might be an uncle's name, but it's somebody who is no longer alive. Their name is on the records down at the property appraiser's office. And if that's the case, it is a mess to deal with. Figuring out who the true owners are becomes more and more difficult and expensive the longer we wait to clear it up through a legal process called probate. You almost always have to go through this probate process unless you have a nice expensive trust. You're going to almost always have to go through this probate process in order to clear that cloudy title. And the longer you wait, or the longer your heirs wait, your kids wait to do it, the more expensive and difficult it's going to be. We have a third problem, which is the longer we wait, especially if people die without wills, it's more likely that the property gets fractionated, meaning it passes to multiple kids, multiple heirs. The more fractionated it is, the much more difficult and expensive it is to do the probate process and do the title work to get it put back together. So how do we avoid it? Some very simple estate planning. So that's what we're going to talk about today. Cloudy title. Why do we not want cloudy title? So cloudy title is when the records down in Aisha Solomon's office, where'd she go? Oh, there you are. Down in Aisha's office, if the records have someone else's name on it, that person has died, the law says that that house now belongs to the three kids, but the records don't reflect the three kids. They have to go down and prove that they are the three people entitled to ownership of the property. So we've got this cloudy title. If you have cloudy title, you can't get homeowners insurance. You can't get your homestead exemption. You can't get a mortgage. You probably are not going to get FEMA funds if a hurricane comes through. You can't lease the property or sell the property, at least not using legally enforceable instruments. You risk losing the property at tax sale, right? There's a lot of reasons why cloudy title is very bad. So how do we clear up cloudy title? Well, it depends. If the prior landowner did some estate planning, put the land in trust, executed a joint tenancy deed or a ladybird deed, which you're going to learn about, then clearing cloudy title is easy. The person who is the surviving joint tenant, or it might be a beneficiary of the ladybird deed, just takes the death certificate down to Aisha's office and says, I'm the next owner, and they say, oh, you're right, great, done. But you've got to do that. You've got to put the property in a form that allows us to avoid that probate process. If the prior landowner dies with a will or without a will, either one, the new owners are going to have to go through what's called court-supervised probate proceedings. This can be expensive, but they're not scary, they're not difficult, and the clerk of the court is here to tell us that, they're here to serve. They want to make it happen easily, but you're still going to have to prove to the judge who the new owners are supposed to be, because we don't want a bunch of undue influence happening or people signing someone else's name. So we got to prove that it really is the landowner's will, but if that happens, we go through the probate process. But the longer you wait to probate, the more expensive and the more difficult it gets. So what is fractionation and why is it so bad? Seems pretty obvious, right? If you've got 4 owners of something, grandma dies, she's got 4 kids, those 4 owners, all 4 own the property in what's called tenancy in common. And when that happens, it takes all 4 people to sell the property, lease the property, mortgage the property, decide who's going to live in it, insure it, get a permit to fix it. It takes all 4. And I don't know about you, do you know where do you get along with your siblings? Do you get along with your siblings' children? Do you know where they all are? If everybody has to agree, it's very difficult. So if we look at a simple situation, and this happens all the time. Grandma and grandpa bought a house, grandpa dies first, then grandma passes, they've got 4 children, and in my original slide they were actually marked in black. So 4 children, Sally, Travis, Valerie, and Michael. If Sally, Travis, and Valerie have all also died, the property is going to be split. Ray's going to get a quarter. Travis's 4 children are going to get 1/16 shares. Valerie's 5 children are going to get 1/20 shares, and Michael is going to get a quarter of the house. And if we're talking about a house that's worth $100,000, 1/20 is only $5,000 worth of that house. So Miriam and Kalia and Mia are not going to want to go to court and do the probate process and pay the lawyer to get their 1/20% share of the house. So if you let the property pass without a will, without an estate plan, it's at high risk of becoming fractionated, and once those interests become fractionated, it's very costly and expensive to get it put back together. So if the house gets divided into multiple pieces and we've got cloudy title because we haven't probated it, because no one of those 11 heirs wants to spend the money to do the probate to get a partial share of this house, then we all just sort of pretend, we just go along, one person lives in the house, and we leave it in grandma's name, and we leave the utilities in grandma's name, and then a hurricane comes. And a hurricane comes, and you can't get a permit to fix the house, you can't get FEMA, you can't get homeowners insurance because it's all still in grandma's name. So we're here to try to make sure that you figure out how not to do that. Don't let it stay in grandma's name. Clear up the title as quickly as possible, when it's relatively simple. Because at least if the 4 children were still alive, let me go back to that. If Sally, Travis, Valerie, and Michael are still alive, they've at least got a quarter shares. But if you wait 5, 10, 20, 30 years to try to probate this house, you're going to have 30 shares. And it's going to become very, very complicated and expensive. Okay, so how do we fix this? How do we fix the problem once we're in heirs property? And the answer is probate, and I believe that is my cue for Stephen McDaniel from 3 Rivers to come talk to us about that. And you can have those too.
All right. Okay, hello everyone. We'll get into probate now. This is the step of the process where, there may be a will, sometimes there isn't a will, but when there isn't a will, go through probate, the probate process. So it's the process, the judicial process whereby a will is proved you're going to court and you're proving that this will, says what you're trying to say that it says, that this property belongs to me. This property from my mom or my grandmother or whoever passed away, that this property should be legally transferred to me. You have to go to court and prove that with a will in the probate court. So that's what the probate process is. And then there's two types of procedures when it comes to this process. There's formal administration and there's summary administration. So the formal administration is the longer version. The summary administration is the shorter version of it. And with summary administration, it don't need to deal with creditors. So the creditors period is 2 years after the person has died. And once that person has died, then at that point the creditors can no longer come after that person's bills, whatever they owe. They can't come after anymore. So the process is shorter because it's a summary administration and there's no creditors. Formal administration is when you try to go to probate court within that 2-year period. So the person has died, but it hasn't quite been two years. And that takes about 6 to 8 months, sometimes longer, could be longer. But creditors can, at that point, try to get repayment from what was still owed. Okay?
Okay.
Okay. All right. There you go.
Thank you. All right, well, good evening. I'm Jess Irby, Alachua County's clerk. It's so good to see such a crowd here. Now, it's great to see everybody taking this serious because, unfortunately, I came just straight from the courthouse here, and that's where we can oftentimes see it doesn't matter how good your family is, how great you think they get along, when things, how it gets, when money gets involved, things can get testy. And we've seen families get fractured, worse than this fractionalization of these properties, and then people end up just ruining entire lifelong relationships over a house, some money in the pot. And so we're talking about the probate process, and so where it's going to go, because here we're talking about, the biggest deal is, we've all heard this saying, failure to prepare is just preparing you to fail. And so really putting in that effort to make sure that when it gets to the court, it's all going to go extremely well and smooth and not a problem. So we heard a little bit about the summer administration and the formal administration, but you can't just choose. And you go, summary sounds great, that's no problem. I want to do the short one, but there's some jurisdictional limits to that of what you can do. But so the clerk's office is where you're going to file this proceeding. The clerk's office is your doorway into the courts to get to the judges. And so you have to come to us, file it either in person. You can use the e-filing portal if you're comfortable with doing that. And so you start by you file a petition there with the clerk's office. And so this type of proceeding would be done in the Family and Civil Courthouse, which is the older courthouse there next to Bo Diddley Plaza if you're heading down that way. And so you can do it by mail, you can do it in person, or you can use that e-portal, which is really a nice, convenient way. You can just do it all at home. But it can be a little tricky if you're a first-time user. And then there's different filing fees involved when you're trying to get into the courts. And so it can range, depending on which type of proceeding you're utilizing, ranging from the $231 filing fee up to the $400 filing fee. And we'll get into which is applicable here in a second. So venue is important. You can't just file wherever you feel like it. Say, they lived up here, but they lived in Miami, but you want to file it here because that seems more convenient. You want to go to Miami. It doesn't really work like that. You have to do it in the proper venue. So the probate petition needs to be done in the county where the person who has passed resided, or if the decedent is not a Florida resident, where that property is located. So maybe they have, we get our snowbirds, and maybe they live up in North Carolina or something, but they got a house here in Gainesville because they enjoy football season. And so if they had a house here, it could be done here, though. Okay, so formal administration, the bigger one, the longer one, and the reason it takes a little bit more, like we're talking about, you have to go through the creditors, but there's also much higher dollar value associated with this. So this is done for estates that are valued at over $75,000, excluding the homestead. If you got a homestead, it's excluding that. This one you cannot do on your own, and you have to have an attorney do this for you. So they're going to have to file it. You have to hire an attorney, someone that specializes in the state, to handle this matter for you. and the filing fee on this one is the $400, so this is the big one, hitting you with the $400 filing fee. So then in your summary administration, you've got a couple of different caveats that you can qualify for it. So if the estate is valued at under $75,000, or if the person passed away more than 2 years ago. And so this one, you got two different filing fees that apply. It's, it's all dependent upon how big the estate is. And so that lower one, the $235, that's for if the estate is valued at under $1,000, and the $345 is if it's $1,000 up to that $75,000. And so, or I guess if it's over the 2 years, then you can utilize the $345. And so we do try to make it, this one, we're able to help out a little bit. The clerk's office, unfortunately, we're not permitted to offer legal advice, but we can make forms available, trying to help folks on their way to get access to the courts. And so if you go to our webpage at alachuaclerk.org, we have pages on there. It has all of the different petitions you can utilize, all the different forms. We also have a self-help section where you can go in. It's actually through the portal, and you go in there, and it's kind of like TurboTax, where it'll ask you questions, and it'll prompt you, and you answer, and it'll help fill out the filings, and then you can submit straight from that to us through the portal. So we're talking about you're planning it all out. You're getting set, you're getting going, your wills. When you decide to draft that will, you're probably going to want to have an attorney probably help you and make sure it's done right and it's legally conforming. So when it gets to court, it doesn't get thrown out. But you're supposed to take that will, and after 10 days after the individual passes, you then file that with the clerk's office. We can't store them ahead of time, and so make sure that you've got them stored somewhere safe. If you got like a fireproof safe or something at the house where somebody knows how to get into it in case you do pass away, but make sure you've got one. But we're not able to store it beforehand, only that afterwards, then we file it in. And you file that along with the death certificate. And we just take the short form, the one that doesn't include the cause of death on there. So getting a little bit more into those resources. So again, you can go to our webpage, you can link through it, the DIY, where it really tries to help you out, guide you as best it can, or just if you want just the raw forms themselves, you can just utilize those. We've had a lot of folks come through, they're able to get the packet, go figure it out, get it filed, and get it wrapped up pretty easily. All right, I think we're back to Three Rivers now.
All right. Okay, so talking about formal administration, this is the steps in the administration process. So, I mean, one of the things that you have to do is identify all the heirs having an interest in the property. So those could be the people in the will, or those are the beneficiaries, but the heirs are the people that have some rightful claim to the property, part of the property. And then we're going to file a petition for administration and serve all of those interested parties. So the petition of administration, it just opens the probate case, and it makes everybody aware that a case is open and that you might be interested in this case. A personal representative will be appointed. This is the person that will, sign papers, will help to gather the heirs, may be involved in, showing up some of the court proceedings, things like that. There's a 3-month creditors period where creditors will have an opportunity. They'll be notified that, that a case has been opened, and they can, state a claim. We'll file inventory with everyone. We'll file a petition to determine homestead status, and then after that, we'll distribute the property to the heirs or the parties as they agree. And that can be worked out as well to arrange how the property will be distributed. Waive all filed claims and then close the estate. The steps in the summary administration will identify all the heirs having an interest in the property. We'll file a petition for a summary administration, similar to the filing a petition for formal administration, but yeah, we'll file a petition there, and a petition to determine homestead status, distribute the property to the heirs, or as the party agree, and then close the estate. So, and then the order determining homestead status of real property. This is an order transferring title out of the decedent's name, the person that died, and you don't get an actual deed with this. And then when the title is transferred from the decedent's name is transferred to whoever the rightful the next people who are rightfully entitled to the property, the interested parties. This is property that will, the creditors cannot come after. Creditors cannot come after this property here. So, and it's transferred, that status, that protected status by Florida constitutional law protects that property from the creditors, so it transfers. So, but we have to go through the process of formalizing that transfer. So it goes from the person that has passed away to one of the heirs. What happens after this gets filed? What happens after the probate documents are filed in the official records? Property appraiser receives copies of the order of summary administration or order determining homestead status. Our office is generally 2 weeks behind the recording. We'll verify the legal description of the parcel, so we'll be looking at deeds and we'll ask you for if you have deeds, or we'll try to find them ourselves and try to verify the description, verify deceased owner's percentage of the property, and we'll update our records to show new owners with percentage of ownership. Okay.
Sorry. Okay, I'm back. I want to clarify a few things. Oops, after I drop that. So I think many of you, we went really quickly through those slides. So if somebody dies owning a home, and we're really mainly here talking about a home, if they die owning the home, they could either have done something, could have done some estate planning by putting it in a trust or putting it in a joint tenancy with right of survivorship, or they could have used a ladybird deed, which we'll talk about in a few minutes. If that happens, the transfer to the next owner is very quick and easy. We avoid the probate process altogether. But if they die owning the home in their own name, whether they have a will or not, they're going to have to go through probate. If the home is their principal place of residence, it will count as homestead. It's not available for creditors. It's usually a little bit more simpler process, but it still has to go through probate. We need that judge's signature on that piece of paper before we can clear the cloudy title and get the property in the name of the new people. But there's also a whole lot of homestead protections and a lot of aspects of what we mean when we talk about homestead that you may not be aware of. And so Lolly Gomez-Roberts, I'm going to get it right, is going to talk to us about homestead exemptions and how somebody gets the protections of homestead. So not all of your real estate is going to count as homestead. But and it matters whether it is in both the probate process and in this later process.
Thank you. Good evening, everyone. It's a big crowd here today, and kind of glad that I'm seeing all of you here, because it means that we are taking proactive measures into trying to make sure that we are doing some estate planning. And like Deanna said, I am here to talk to you about what is a homestead exemption, what does it mean, how do we get it. The majority of you, if you're homeowners, hopefully you filed for it and you've received it, but what is homestead exemption? So through the probate process, we talk about your homesteaded property, and it's basically your primary home. Homestead exemption, the one that I am going to talk to you about, it's a tax exemption that is provided to homeowners. Homeowners that own the property, of course, and make it their permanent residence or the permanent residence of somebody who's legally or naturally dependent upon them. What is this homestead exemption? What does it do? Do you already have it? So majority of you might already have this exemption. This is an exemption that you filed for when you initially purchased your home. Following the next year, so January 1st, that property was yours, you went ahead and filed for your homestead tax exemption. What that exemption did is it put a tax break on your home. It covers up to the first $50,000, and it gives you a $50,000 tax deduction. It equates to about $925 of taxes every year, but it also comes with something called a Saver Homes Cap. That exemption, it's on your home, it renews automatically, and it stays on the property as long as it continues to be your permanent residence. The benefit of having the homestead exemption, apart from being able to take advantage of that as a property resident, is it opens you up to other tax exemptions. For the majority of you, this is, if you're, those of you that are in the older crowd, if you're over the age of 65, it also gives you a break for a senior citizens exemption. What it does, it maintains your taxes at a very low rate compared to somebody who probably doesn't have a tax exemption on the home. So one of the main concerns that everybody has is, when I pass away, okay, when this happens, what happens to the responsibility of the tax payments that the heirs are going to inherit if they inherit this home? What happens to all those tax exemptions? The homestead tax exemption is an individual tax exemption. What does that mean? It is granted to the homeowner, to the original applicant or applicants, okay, and it stays between overlapping spouses or the single owner that owned this home, and it will renew automatically every single year. What happens is whoever takes over the property, whoever's to inherit the home, their responsibility is to notify the property appraiser's office that the original applicant, the original exemptee on our records has passed away. Okay, so that's their responsibility. Why? Because when that person passes away, January 1st of the following year, that exemption is supposed to come off. That property can no longer benefit from those tax breaks. Now, one of the main concerns we all have is not only what is our heir's responsibility with their home, what is their responsibility with the taxes, what is the responsibility with the ownership, but another thing is, what happens if your heirs are going through probate? But the definition of the fact is that one of your heirs at some point either made it their permanent residence along with you, or it's going to be their permanent residence. It was determined that your son, or your daughter, your grandson, your granddaughter, a niece, was supposed to inherit the house, and this was going to be their primary home. So what happens, because your tax exemptions are coming off, their tax liability is going to increase on that home. They're going to be paying more taxes. So the question is, what's going to happen through the probate process? Okay, so let's say you did not do a Lady Bird deed. Okay, your heir cannot come to the office with a copy of your death certificate and say, hey, my aunt, my grandmother, she passed away, or he passed away. Okay, we'll update your information, we'll give you a homestead application, we can grant you the exemption. What happens if that's not the case and they have to probate the home? This is what happens. The property appraiser it's in the responsibility to have to take the exemption off. That's currently on record. But whoever the heir that's going to make that property their permanent residence, they can come into the office and file for their homestead tax exemption, even if that home still is under a cloudy title, meaning it's still under heirs. Okay? They can come in, they can file for the exemption, and the property appraiser will hold that application on our records until probate finalizes and it makes a determination of who is to receive that property and how much, percentage-wise, the applicant is going to receive after probate. Okay? In the meantime, as probate is going, your heir might receive a tax bill without the tax exemption. Okay, and this is one of the things that Diana talked about. Not only does it open the fact that they can get insurance, not only does it open the fact that they can get a homestead exemption, they can sell, they can lease the property legally, they can get FEMA help. Also, they are going to have a burden until that property is probated to pay the tax bill as it is without any tax exemptions. Okay, now, when they probate, and the court determines who owns the property, if you didn't leave a will, or they went ahead and did it according to your will, the exemption can be granted to that heir that has made the property their permanent residence. Now, with that said, I am going to go ahead and transfer over to the Alachua County Tax Collector. John? Diana first.
That's all right. I just want to make one comment about that homestead. Right, everybody, I know what every one of you is thinking right now. which was if someone passes away and I'm about to inherit that home, I'm going to wait 2 years and then no creditors. And I'm not going to tell anybody that I got the home because I want that homestead exemption to stay on, right? But we're going to find out a little later why that's really not a good idea. You're better off telling everybody, and we have processes to allow that exemption to continue. But John's going to tell us, John Powers, our tax collector, is going to tell us a few things about the tax collection process.
All
We all
right.
love him.
Okay, I'm going to set this down, and I'm going to talk to you. They put me on a hook, so they're going to yank me off real quick. How many of you right now feel completely overwhelmed? Absolutely. So do I. It's okay. Tonight's not about you learning all the facts and details. That's not what tonight's about. Tonight is about bringing awareness, and then you'll follow up after tonight with these experts and some legal experts, and you'll protect your property. So don't worry if you feel overwhelmed. A lot of this is just going over your head. It's okay. Tonight's the first step of many steps you're going to take. So let me ask another question. By show of hands, how many of you own your property outright? Fantastic. Congratulations. I'm very perceptive. None of you have a tail because you worked your tail off to pay that house. Did you not? You did. So it's your responsibility to make sure that the next person that owns that house can work their tail off to preserve it. The last thing you want, see, I'm a mind reader, the last thing you want is for your property that you've worked so hard for to get lost. You know the best part about being a tax collector? Nothing. No, there is something. I do get to help people. The worst part about being a tax collector is sometimes I have to exercise the law that negatively affects people. Sometimes I have to exercise a law that negatively affects people. What must we do to maintain and keep our property? What do we all have to do? Say it with me. Pay taxes. Believe it or not, you put my name on the check, but I don't keep the money. So, I want you to think about this. As you're preparing, when you're no longer here, that'll happen to each and every one of us, hopefully not tonight. But at some point, we're not going to be here. We want to make sure that we make the right decision in who we put responsible for our property. What's your name, sir?
Bobby Collins.
So Bobby Collins has a jet airplane. And he says, John, you're just a fantastic guy. I want you to have my jet airplane. I'm going to jump up and down. I'm going to go talk to my buddies. Guess what? I got a jet airplane. I'll tell you right now, I have no business owning a jet airplane because I'm not a pilot. I can't afford to keep it at the airport. I can't afford the taxes, if there are such a thing. I can't afford the jet fuel. So Bobby meant well, but he gave me something that I can't meet the responsibility that it takes to hold on to it. So I want you to think about your property, how hard you work for it. Who do you know that can handle that responsibility? Well, I don't need a tax collector preaching to me. Well, let me give you a story. My father with an 8th grade education. See, the apple doesn't fall far from the tree, but. So my father has an 8th grade education, works his tail off, makes him and my mom's house payment, works the second job to make my grandmother's house payment. And guess what happened after 30 years? They had it paid for. Woo-hoo, congratulations, that's the American dream, it's wonderful. There's 5 children in my family. Here we go, ready? So John wears a jacket. He's got a fancy job. He's our collector. He's really something. Well, look, I'm from an average American family. You know what average means? We got everything from jail to college and everything in between. So I have a sister, heaven forbid, but it's true. She has substance abuse problems. Do I love her? Yes. Do I respect her? Yes. But she has issues. So when my grandmother passed, what do my parents do out of love? This is what she needs. We're going to give her your grandmother's home, and it's going to give her a fresh start. In 28 months, it took my father 30 years to pay for it. In 28 months, it was gone. She didn't have the mental or financial capacity to handle that responsibility. The whole family knows it now. We made a big mistake, but our heart was in the right place. Do not make this decision with your heart. Period. Use your brain. Who can take care of that property? Now, my parents could have said, we want you, John, your other sister live there. But when this gets thrown to 5, 10 heirs, how often do we have 10 people agree? Doesn't happen. Let's go to families. How often do we have 10 family members agree? So you told me earlier, you must pay taxes or you lose the property, correct? So let me ask you, if there's, we'll reduce it down to 5 owners. Small family, 5 owners. Who owns the property? All 5 do. Bobby, Bobby pays the taxes. He pays them the first year, the second year, the third year, the fourth year, the fifth year. Who owns the property? Bobby or all 5? All 5. Don't ever forget that. So Bobby gets tired of paying. He says, you know what, John? I'm not writing you a check this year. Because my brother's son's living there. He shacked up with that girl. She's not working. They're lazy as anything. My brother won't pay the taxes. My sister's in New York. Sound familiar? My aunt's in California. No one wants to pay him. I'm sick and tired of paying them. What can I do? I say, there's nothing you can do. There's nothing. So guess what happens? He quits paying the taxes, and it takes 2 short years. The home gets sold on the courthouse steps. That is a shame. So, I'll summarize. I can't believe they haven't hooked me yet. You ain't been off the stage. So what you're going to do after tonight, you're going to sit and think and talk with your loved ones, and then you're going to get legal assistance. All right, I fill out forms tonight and have your problem solved. My parents went and had a will made, got their property taken care of. I know it was under $700. It may have even been under $500. It's not that expensive to get you an attorney to handle this. And guess what? When they pass, me and my sisters, if we want the house, we can go pay probate and all that other stuff. But for them to just at least take that first step, it was probably $500 or $600. So don't let tonight scare you. It's not about scaring you. It's about motivating you to take care of business. Because in our office, we have delinquent taxes every year. People get in hardships and they can't pay their taxes. That's okay. Eventually, 98% of them get paid. But I can tell you now, and my tax director, Matt's going to go over a few slides with you, a lot of heir property don't get paid because Bobbies of the world say, I'm tired of paying if I don't own it. Does anyone in here want to pay my taxes this year? We don't want to pay taxes on something we don't own, or we own a small fraction. So I can assure you, if your property that you work so hard for lands in the hands of multiple people, there's a very good chance at some point whoever's paying the taxes is going to say, enough. I'm tired of it. I don't care. The property can go. Because Bobby can get title to the property if his 4 siblings agree to give it to him. Hello. thank you so much for having us. Relax. Mine was the midpoint. It was a halftime show. You can just take a deep breath. And we'll wrap up. You have taken the first step. The next steps aren't that difficult or intimidating. So just breathe and we'll get there. And I do have a notice coming to you in November. Go on vacation that month and pay that. Thank you so much. This is all I do. Matt Geiger in our office is our director of tax. If you know anyone, if any of you are in an heirs property situation right now, call Matt in the tax collector's office. He'll look it up, he'll let you know where it stands. And if any of you are in a delinquent tax status, that's not the end of the world, but it takes a lot of due diligence to make sure your property doesn't get lost. But he will gladly help you. Oh, I'm so sorry, but I do have to give you one more tidbit. Yesterday, a friend of mine called, says, John, my neighbor said he's going to have to move because his taxes are too much. Me and my husband, ours is only $1,000. Can you look it up? All the homes in our neighborhood are the same. Their taxes, my friend, $1,000. Their neighbor, the exact same house, same size, built the same year, $4,000. $4,000. You know what the difference is? Real estate today is so expensive. They bought in 1994, they have protections. Ms. Roberts was talking about Homestead gives you a lot more protections than just $50,000 of them. It stops the crazy escalation of your value. You're capped. So I told this lady, I said, you have been capped, but your neighbor doesn't have Homestead. Their taxes are $4,000. If your taxes are $1,000, when you tax, unless it's your spouse, your homestead is going to come off. Your heirs are not going to pay $1,000. What are they going to pay? A higher amount. More motivation for you to make sure wherever your property goes that the person has the mental aptitude to handle that property and the financial aptitude to handle it. So this is Matt Geiger. He's our Director of Tax Operations. I really enjoyed seeing all of you tonight, and we will all stay after the presentation to answer your questions. So thank you so much.
Yeah. Thank you. Thank you, Mr. Power. Let me just share with you a few statistics. So if taxes aren't paid, every year there's about, in our county, there's about 100,000 properties, a few more than that, and about 6,000 go delinquent every year, or 6,000 we sell tax certificates. And so, but when it's all said and done, this past year in 2022, 86 properties were sold because of back taxes. And so that's a pretty small percentage. And then out of that 86, 17 of those properties were heir properties. So about, almost a little more than 20% of the properties that sell are heir property. And if you look at 2021, we only sold 48, which we're proud of that, 44 the year before that. And so, but a pretty good percentage of those properties that sell are heir properties. So, our vision in the future is that we can reduce that. Our goal is not to sell property. We have to sell property by law if under the circumstances dictate. And so, but as the tax collector's office, our goal is to collect taxes, not sell property. So we definitely want to keep our numbers as low as possible. Let's look on this side over here. It's 2022, and we had in blue 86 properties. That represents the properties that were sold, and out of that 86, 17 were heir property. And then the next year's 2021, 48 properties sold. I'm glad you said that. We'll change the slide to make it more visible. Yes, thank you. And then we had 7 properties that were heir properties. So it kind of just gives you an idea of the proportion of properties that sell and how many of those are heir properties.
What's the numbers over here on the far left?
So 140. So in 2018, we sold 122 properties for taxes. 24 of those were heir properties. So we're we're hopefully selling less and less. That means we're collecting more and more taxes. You know, the taxes are getting collected. Yes, you're welcome. Thank you. So just a few frequently asked questions we'll go over. Can I see if taxes are paid or unpaid on a property? And the answer is yes, you can. Property tax information is public information. It's available on our website. You can also call our office, and you can check on your neighbor's taxes. You can check on your children's taxes. It's kind of fun. So anyway, but it is public information. How many heir properties in Alachua County have delinquent taxes? So this is an approximation. There's approximately 1,676 heir properties right now on the tax roll, and there are currently 368 heir properties with delinquent taxes. So that's like, out of all the heir properties, 1 out of 5 have delinquent taxes. So that's a pretty good statistic to look at. How long can taxes be unpaid before the property is in danger of being sold? So property taxes, once they go delinquent, you have 2 years from the date of delinquency before the tax deed sale process can begin. And it doesn't happen overnight. We try to slow the process down. We try to communicate to the property owners. We want you to realize your taxes are delinquent. We want to give you time to get them paid, figure out how to do that. And so we do our best to slow that process down. But by statute, you can't lose your property before that 2-year period is up. So having delinquent taxes doesn't mean you're a bad person. It doesn't mean you have bad credit. It doesn't do any of that. It's just kind of like a loan. So it's not a bad thing necessarily. We don't look at it that way. That's why I have a job. So that's not a bad thing. But it does cost you money if your taxes go delinquent. It does usually the amount due is more than that. It increases. So we'll do our best to help you get those taxes paid before they're delinquent. So another question: if I pay the taxes on a property, can I own the property? So the answer is you cannot own the property by just paying the taxes. So in order, you would have to purchase the property at a tax deed sale and be the highest by being the highest bidder at that sale. So that's a whole process that happens. How can I purchase a tax certificate? So purchasing property and getting a deed is different than purchasing a tax certificate. So a tax certificate is a tax lien on a property, and every year when property taxes go delinquent, we sell between 5,000 and 6,000 tax certificates, and we do that because the local government, those are funds that haven't been collected, and our local government needs those funds. So we basically broker a loan with a third-party investor. You could be one of those investors if you'd like, and you could buy these certificates, and you earn a little bit of interest. And so that's a way the government gets the money to operate on, and the property owner gets a loan for 2 years, basically, until they can come in and pay. So it's a pretty good, it's actually one of the best programs in the nation, the way the state of Florida does it. So you've got a 2-year period before you're in any danger if your taxes are delinquent. So you can purchase a tax certificate annually. We sell those. We start the sale about mid-May, and it finalizes on June 1st every year. To be awarded a tax certificate, you have to bid the lowest interest rate. So the goal there is to get the homeowner the lowest rate of interest on the certificate. So that's a good thing. So if I purchase a tax certificate, how can I become the owner of the property? So after you hold that certificate for 22 months, you can then apply for the tax deed and force the property to public auction. There's approximately $1,000 of fees that you would have to pay to get that property to the auction, along with the other delinquent taxes that are due on the property. So the property goes to public auction. The opening bid starts out at with the amount of taxes and fees. If it's a homestead property, it also starts out they add half of the value of the home to the opening bid. And so and then it goes to public auction. The high bidder then becomes the owner of the property. If you're the certificate holder and you're not the high bidder, then you get all your money back. So tax certificate investing can be a positive thing, but there are risks. All right. Just a quick delinquent tax timeline. So taxes become due and payable November 1st each year. So we pay toward the end of the year. So this November, it will be our 2023 tax bills will go out, and that represents the year from January 1 to December 31st of 2023. So they become delinquent the following April 1st, and then we sell certificates on June 1st. 2 years later, the property can be sold at a tax deed sale if the taxes are unpaid. So we'll be around after this is over, and I have some business cards. If you have any questions, come see us. Here's our contact information. I've got our phone numbers, and we've got a great website as well. But if you have any questions, we welcome those, and look forward to speaking with you. Thank you.
All right, quick quiz. Which is better, to pay your property tax or to not pay your property taxes and go out and go on a cruise on your credit card, or to take a cash advance on your credit card to pay your property taxes? Why? Because you can have your home sold, even if it's homestead, for non-payment of taxes, but they can't take your home if it's homestead for those credit card debts. Just a little tidbit of information, in case you're worried about that. Okay. I think we're back to Lolly. Is going to come tell us about what happens. So in case we're playing musical chairs up here because you kind of have to do that as well. You go to the courthouse, then you go to the property appraiser, then you go to the tax collector, then you go back to the property appraiser, and then we're going to get you to Three Rivers.
So it looks like I haven't lost my chair in the musical chair game, huh? Okay, good. So at the beginning we talked about how do we get the probate filed, and Jess came up here and he told you, well, this is the fee, this is what you got to do, blah, 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 you got 2 years. They talked about all of that. Three Rivers told you the two options you have, if you wait 2 years, if you do this, if you do that. And then they talked about what happens with the exemption after probate is finalized. And then I talked to you about the fact that, make sure your heirs, if one of them is going to be the permanent resident, that person comes in and files for the homestead tax exemption and whatever other tax exemption they might qualify for. They might not get it right away, but we told you we hold it in the records and then we wait for the court to make a decision. And this is what happens. So once probate is finalized, okay, our office gets two types of processes. The only thing that we pick up are deeds, either quitclaim deeds, warranty deeds, ladybird deeds. That's what it's rendered to us for us to make updates. So with that said, documentation from probate is not automatically going to be deposited on our records for processing. That means whoever the heir was, whoever probated this home, it's their responsibility to come forward after probate finalizes and say, hey, probate finalized, here's the documentation. Once that happens, our office is going to do a couple things, okay? They're going to contact our office. One of the first things we're going to do, on the exemption side, is we're going ahead and we're going to revisit the original application, okay, that was submitted to ensure it's still in good standing claim. What does it mean, good standing claim? So when I told you they can come in and file for the exemption, the only thing that can be wrong on that application is the fact that they still have not received ownership of that property. Okay, that means everything else they still need to have. So there's certain requirements. Get this thing out of here. Okay, so there's certain things that they have to meet, just like you had to meet when you file your exemption. Your heir has to meet when they file the exemption. What are those things? Well, the first one they're not going to meet, which is own the property as of January 1st of the year they filed the application to be able to receive the exemption. Because the property had no estate planning, we got to wait for probate to finalize to get the first step. But then there's a couple other things they have to do which they need to have that in order for us to grant that exemption retroactively. One of them, they have to have residency in the U.S., permanent residency. Two, they have to be permanent residents of the state of Florida. Why? Because it's a tax-driven exemption that it's for residency-based Florida residents. And three, this property has to be their permanent residence as of January 1st of the year they file for that exemption. Okay? So when they submit this application, everything with the residency they have to have. We know ownership is not going to be there. So when the ownership gets cleared up, what does it mean? We'll revise to ensure the application is still in good standing. They have to maintain all those three items. That means they have to continue be residents of Florida, and they have to continue being residents at the property for us to go back to the application and retroactively grant them the exemption once probate finalizes. What happens is this. Remember how I said because property had to be probated, because we had no estate planning, whoever the heir is, and here it goes back to John, and you figuring out, make sure that whoever you leave this house can pay $4,000 and not the $1,000 you were paying, because we talked about the fact that they're going to have to pay for a couple years until probate finalizes, or a couple months, they're going to have to pay the taxes, okay? That means, and even after probate finalizes, our records are going to be fixed for the current year. Let's say we review the application's okay, we updated our records, either order determining homestead or summary administration will update our records. We'll go ahead and grant the exemption for the current year and submit all the previous years to be reviewed for a possible tax roll correction. Now, keep in mind, statute limits us to 4 years. We cannot go back more than 4 years. So it'll be current year plus 3. That's how long it takes. Anything that is current year, it's going to be immediate. The other 3 years that have to be refunded, they're going to take some time because they have to go to the Department of Revenue. Department of Revenue is going to need the required documentation, the probate documents. That's the thing. They're always going to go back to ensure that this tax exemption is being granted properly. Now, here's the thing that we talked about, the 2 years, and then, some people wait because they won't be creditors at the property. So somebody passes away, they stash the debt certificate. They're not going to tell anybody that their grandmama passed away. So whenever they probate, they don't have any creditors. Well, guess what? Whenever you probate, there's somebody that's going to find out, and it's the property appraiser's office. And we're going to find out not only that you stashed that debt certificate, but we're also going to find out that you've been paying taxes with your grandmama's tax exemption. So you inherited erroneously their homestead exemption. Maybe they had a senior's exemption. Maybe they had a widow's exemption. And when you start staggering all these exemptions up, they paid $329 in taxes, and that's how much you paid. But guess what? How much you were supposed to pay? $4,000. So what happens to those $4,000 that went unpaid? If the heir realizes the property tax exemption stayed on the property claimed, so we're going to go ahead and we give everybody the benefit of the doubt. You did not know, your heir did not know, they were not aware that they had to cancel those exemptions. They can go ahead and report that directly to the property appraiser. As soon as they realize that, they can come into the office, they can call us, and they can go ahead and make the changes. They can notify us that that exemption needs to be removed immediately. Okay? They had a change of heart. Forget it. I prefer paying the creditors over losing the house. They can come in. Remember, that is the first responsibility. That's why it's very important that you leave somebody who is capable to manage this sort of things. There's a lot of what I call legalese that goes when somebody passes away. Make sure you leave somebody responsible enough, not only that they can pay the taxes, but also that they know that they have to file some sort of procedure, or who to ask, or they know that they have certain questions they have to ask. Exemption tax lien versus current year delinquent tax certificates. So this is the reason why we say it's very important that your heirs are aware that your tax exemptions are yours and not theirs. If you pass away, if the property owner passes away, and the heir fails to notify the property appraiser's office, and that exemption continues renewing automatically every year after, okay, they now are liable for what we called an illegal exemption that stayed in place. I like to call it an erroneous exemption, but there's nothing pretty about it. So because of that, your heirs now, whoever gets the property, now they're going to be responsible not only to pay back the $3,125 they saved on taxes, but now they have to pay a penalty of 50% on top of that and 15% every year after. It's big. When you start calculating that up, it's a lot. So it makes no sense to save $3,121 when at the end of the day, they're going to have to pay almost $5,000 back. So it's better off to unstash that debt certificate and bring it forward. Now, we are aware that this is a process that's very confusing. And I know because I can see everybody's face. Everybody's face, you know. Not everybody here went to law school. Not everybody here has worked for a tax collector or a property appraiser's office. So it's not expected that your heirs will know. So let's say they did wait the 2 years so they could go ahead and do the probate where, you know, the creditors can't come behind anything on the property, but they forgot to notify our office. They can go ahead and make the notification themselves to the property appraiser's office, and it will be under review for penalties and interest, okay? If we don't identify what we call a tax lien, an exemption tax lien, but the property owner brings it forward, in this case the heir brings it forward, it allows our office to make a decision in regards to that 50% penalty and that 15% interest. Okay, what I want to make clear is there's a distinction between current year delinquent tax certificates, which are put in immediately. Once you don't pay them, you go in that 2-year ticking time bomb thing, you know, versus an exemption tax lien. An exemption tax lien is what I like to call a dormant lien, okay? So delinquent taxes generate a tax certificate. Why? Because you did not pay your taxes, okay? As previously mentioned by the county tax collector, Matt and John. And this can go ahead and a third party can go ahead and try to push for a sale on the property because of delinquent taxes. They can force it, and within, you know, 28 months or so forth, the property can be lost, which means 2 years unpaid. An exemption tax lien, once it's identified by the property appraiser, unlike a tax certificate, will stay dormant on the home. What does it mean? It means, I don't know if any of you have noticed, but we can get away with anything except owing money to the government. We can get away with a lot of stuff except for that. So when there's a tax lien, who is the first tier that has to be paid? The government. So if your heir is ever going to sell that home, but there's a tax certificate, a tax lien from an exemption, it'll stay dormant. This will not generate a tax deed sale, but it will stay on the home, and they cannot sell that home until that exemption tax lien is satisfied. So the unpaid taxes cannot be sold, and this will not result in a tax deed, like I said. The lien will stay on the property until the payment arrangement is satisfied. The heirs either pay it in full, they can pay little by little, they can sell the property. Now, the heirs will be notified that there will be a tax lien placed on the home. It will give them up to 30 days in which they can satisfy the amount beforehand so it doesn't get recorded. Once it's recorded, it's sent to the clerk of courts, and they will be sending notifications in regards to the property for this. Now, the tax collector, I can say this because we have several cases that fall in like this. Trust me, they have a great lady that works for them. We throw her phone number in all of our mailouts. And she works directly with them to ensure what years need to be paid so less interest is accumulated. So it gets paid faster. She'll work with them. You know, it's dormant, it'll stay there. And another thing is, because if they bring it forward, let's say our property appraiser decided to take off the penalties and interest, it will not accumulate the 15% interest every year as versus a regular lien. So it'll just stay there, not accumulating anything. Whatever the notification says they own, that's how much they owe. And they can pay little by little, trust me. I've heard her before say, you can pay $100 and this person owes $12,000 in a tax lien. I'll take $100 this month. I'll take $200 next month. Okay? But we don't want to put them through that process. We just got to make sure that, you know, we tell them, start lecturing them now. When I die, my exemptions come with me. You throw them in my grave, you go get your own.
Thank you. So you know, Santa Claus knows what's going on. You all, many of you got a card from the property appraiser's office. That's why you're here. Yes, they know what's going on. So don't think you're going to be able to fool the property appraiser's office. They are keeping an eye on things. They know, and if somebody passes away, if the homeowner passes away, they mark it in their files as heirs property. They're pretty sure that we've got cloudy title. They're waiting for somebody to come clear this mess up through the probate process. And if you wait 20 years, your heirs wait 20 years, you could have a serious tax lien on your home, right? You could have a lot of debt. Even if they're paying the taxes and we don't force a tax sale, there could be a lot of debt on the home that makes it not worth anyone's while for one of those 14 heirs to go through the process of probating it and paying all the taxes and hiring the lawyer in order to get a 1/15 share of a $100,000 home. That's really where we're at. So can all of this be avoided? This is why you all sat here through an hour and 15 minutes of learning, hopefully the horrors of what not to have, not to do. And now we're going to turn it back over to Three Rivers to talk about some ways we can avoid this.
Okay, so let's talk about how we can avoid some of this. So the first thing is to, be proactive. Prevention is usually the best approach with, most things, and this is the same thing here, estate planning. So with estate planning, there's various things that you can do. We'll talk about a few of them here, but we can go deeper at a different point. There's the last will and testament, there's advanced directives that deals with a lot of medical, and then there's the ladybird deeds. I'm going to talk a little bit about these three. But first I want to get into the living will, and that has to do with the advanced directives. So with the living will, it's an end-of-life document that makes known your wishes about being kept alive artificially, when you have a terminal condition or an end-stage condition or in a persistent vegetative state. So if any of these three things are going on and your doctor has determined that there's no reasonable medical probability of your recovery from the condition, if these scenarios are going on, you can make a determination whether you want to be kept alive artificially. That's a living will. It gets confused with a last will and testament. You make the living will. It takes effect when you're at the end stage of your life. Okay, now to the living will. What to think about when you are writing a will? What should you have on your mind? First of all, the fewer the beneficiaries, the better to avoid the fractionation of real property that was talked about earlier. So if you have a whole lot of beneficiaries that you're giving your house to, it could create an issue where you have, a lot of people have to agree on making decisions relating to that property. Think about who is best and able to pass on the home. who should you pass the property on to, who's going to take care of it the best, who can financially handle it, like it was talked about earlier, things like that. Can you give different beneficiaries different property to show that you love them equally? I know there's a lot of emotions involved when it comes to passing along property, so just keep that in mind. Write down instructions regarding what you want to happen with your real estate. You can write down, what you want to happen. Not everything is legally enforceable, but you can kind of put your wishes down, and we can see what happens legally. Can you incentivize your beneficiaries to follow through with probate to clear title quickly? Do you know someone who can be appointed personal representative of your estate who you trust to quickly and efficiently administer and probate your property? So the personal representative, this person, like I mentioned earlier, they'll be signing papers, but they'll be helping to administer the property and carry everything out. So the person that you want in that role should be a responsible person that you trust. Next up is enhanced life estate deeds. These are sometimes you might hear them called ladybird deeds. So this is a way to avoid probate entirely when it comes to your property that you want to pass on to someone else. So the grantor or the owner of the property maintains ownership of the property during their lifetime. So even though you're alive, you're passing this property to someone else, person B, you pass the property to them. When you die, person B gets the property. But while you're alive, you can still make decisions regarding the property. So you can pass it to somebody else, you can give it to person C or person D or whatever you would like. So it gives you a little bit of flexibility, when you deed property to somebody else. Like I said, you can sell the property, give it away. So there's many different things you can do with this. You can change your mind on who you want to give the property to when you die. So a lot of flexibility there with the ladybird deed. And just deeds in general, please don't do them yourself. Reach out to an attorney with us at Three Rivers Legal to help you with that, and we can put together deeds in the right way. There's other deeds, as a deed called a joint tenancy with survivorship rights. I know some people probably heard of that. That's another route of avoiding probate entirely because, when you die, the property automatically goes to whoever you leave it to, automatically. If you specified you want the deed, that you want that to happen in the deed. And designation of healthcare surrogate. This relates to advanced healthcare directives. It's a legal document that names who you want to make medical decisions for you if you are unable to make these decisions. So imagine having dementia or some kind of incapacity, or you're recovering from a surgery, or there's some long-term illness. You can, it kicks in when you can no longer make those decisions for yourself, medical decisions, and you have already determined who you want this person to make these decisions for you. You already have that person written down, and that person will make your decisions for you because you can't make them yourself. And that's why it's important to find somebody trustworthy, someone that would carry out your wishes as you would like. Okay.
I promise this is the last slide, but I want to make 2 points. One is what he was just talking about, what Stephen was talking about in terms of your estate planning ideas. Think about it as you've got yourself, your health, who's going to make decisions while you're still alive if you're unable to do that. That's your designation of a healthcare surrogate. Who's going to take care of you if you are incapacitated in some way? Who's going to make the decision, unfortunately, to pull the plug if that's what you want to have happen? That's your living will and your designation of healthcare surrogate. Your property is handled by completely different instruments. And so you can do a last will and testament that becomes effective after you die. You can also have a durable power of attorney. You can execute a durable power of attorney and give somebody during your life the ability to manage your property. So but make sure it's a durable power of attorney. But durable powers of attorney terminate when the principal dies. So you may designate your daughter as your power of attorney. You may designate your daughter as your personal representative in your will, but the daughter still is going to have to go to probate with the will. As soon as you die, the power of attorney is no longer effective, and that the daughter's going to now have to start over and do the probate proceedings to get declared the official representative. Now, life insurance, right? You all know how life insurance works. You fill out the form, you pay them the premiums, and you designate who you want to have take your life insurance when you die, if you die, right? And you can change your beneficiary designation on your life insurance. You can put a beneficiary designation on your bank account. That's what a ladybird deed. Until recently, you could not put a beneficiary designation on real estate. But now, the ladybird deed allows you to essentially do that. You execute a deed, it designates who you want to have take the property at your death, but until you die, you can change it at any time. You can change it, you can sell it, you can manage it just like you can do with your bank account. It's only if you die and it's still, that beneficiary designation is still on the record, that person then is able to take the property, but you avoid probate through that. So I highly encourage doing that. Community resources. We've got the 8th Circuit Self-Help Program. So at the Alachua County Courthouse, there is a library, a self-help center where you can go down. Law students are often there they're only there on Fridays because the rest of the time they should be in class. They are there to help you fill out forms. There are people there that can help you do all of that e-filing that Jess Irby was talking about. We try to have resources for you there. Our law students are available on Fridays. Three Rivers is a low-income service, so if you qualify, you can get free services or possibly reduced legal services. Yeah, and they've got a table in the back. There's the Gainesville Community Reinvestment Area. If you live in a certain area of Gainesville and you have a certain income, they also offer some services. There's also some local lawyers in town who will provide services for doing this. And coming soon, I'm hoping the University of Florida, we've gotten a grant to start a law student clinic to handle the heirs property. But hopefully you all have I hope, understood why you don't want your property to fall into heirs property status. And you remember the 4 terms, right? Fractionation, we don't want that. That's where too many people have title to the property. You don't want cloudy title. That's because you wait too long. Your heirs wait too long to clear that title. All sorts of problems happen. Probate gets more expensive and more cumbersome if you wait too long. So get that probate done early, do the tax homestead exemptions, do everything you need to do right away. And finally, the best thing you can do is some estate planning. Thank you all for coming. And please, we're all here to ask questions, and we're happy to talk.